So welcome to Constitution Day and to the Social Science Forum here at UMBC. It's co-sponsored by the Department of Political Science and also by the Department of Public Policy and the Department of Africana Studies, and also the Office of Student Life. Today we're going to hear from Dean Carla Pratt, who is Associate Dean of Academic Affairs, the Nancy J. Lamont Faculty Scholar, and Professor of Law at Penn State University's Dickinson College of Law. She teaches in the area of constitutional law and race and American law, as well as some other subjects. Dean Pratt's research focuses on legal construction of racial identity and the role of race in the legal profession. Her recent book, The End of the Pipeline, takes a qualitative look to discover what interventions facilitate the entry of African Americans in the legal profession. Her current research, which will be the focus of today's talk, examines higher education affirmative action cases and argues that the indeterminacy of the protected interest in those cases has to be addressed if race-based affirmative action policies are going to survive constitutional scrutiny under the newest cases. Before joining the Legal Academy, Dean Pratt practiced law as a civil litigation attorney as a Deputy Attorney General for the state of New Jersey in civil litigation. She was also a commercial litigation attorney for a large firm in Philadelphia. She graduated with honors from Howard University's School of Law. So without further from me, Dean Pratt.
Thank you, Dr. Davis, for that introduction. And thank you to Dr. King Meadows and the Department of Political Science and Africana Studies, as well as the Student Life Group, for hosting today's event and inviting me to participate. On this Constitution Day, I ask you to pause with me for a moment to consider a particular part of our Constitution, the part that is especially devoted to the principle of equality. You probably all studied the 14th Amendment's Equal Protection Clause, so you know that it provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. It was enacted by the U.S. Congress during the Reconstruction era in order to extend the guarantees of the Constitution and all laws to the newly freed slaves and future generations of citizens of the U.S. During President Abraham Lincoln's administration, by an act of Congress called the Freedmen Bureau's Bill, passed in 1865, the same Congress that adopted the 14th Amendment to the Constitution created the Freedmen's Bureau as part of the Department of War in order to aid former slaves with assistance with food, housing, education, health care, and employment. The creation of the Freedmen's Bureau through passage of the Freedmen's Bureau Bill reveals that Congress realized that it was insufficient to merely free the slaves and to merely declare slavery by law unconstitutional. Congress recognized that it was necessary to take some additional steps to repair the harms that had been imposed on an entire class of persons by the institution of slavery. Congress recognized that it needed to take affirmative action to help the newly freed slaves take full advantage of their newfound freedom. So Congress proposed laws aimed at racial rehabilitation. That is, laws that were aimed to help the former slaves as a group to overcome the subordination imposed by slavery and become self-sufficient, contributing members of society. Special benefits were proposed for these newly freed slaves. They included land allotments, crop assistance, education, health care, and these special benefits were proposed not for all Americans, but only for the newly freed slaves, as a way of remedying the various sectors of racial injustice that were imposed by slavery. From this brief review of history, we see that the same Congress that drafted the 14th Amendment's promise of equal protection was in favor of special benefits for black folks. So how can it be that affirmative government action aimed at alleviating racial inequality could ever be an unconstitutional violation of the 14th Amendment? as is posited by some who oppose race-conscious affirmative action. Perhaps it is because on the issue of affirmative action, government action aimed at alleviating racial inequality, the court has not taken an originalist approach to constitutional interpretation. Rather, on this issue, the court seems to have viewed the Constitution as a living document, ever evolving, so that the Constitution's Equal Protection Clause ultimately is interpreted as a provision that not only applies to the racial minority, but also to the racial majority, and in fact precludes government from taking affirmative action to remedy racial inequality suffered by racial minorities in some instances. By reframing race-conscious affirmative action as government-sponsored racial discrimination against whites, equal protection jurisprudence has firmly entrenched the existing racial inequality that is the vestige of Jim Crow and slavery. But the current state of affirmative action jurisprudence in the higher education arena cannot be understood without tracing the debate surrounding its constitutionality. Today, colleges and universities use affirmative action programs to diversify their student bodies, and they began this process in the late 1960s in response to the demand of the civil rights movement. Blacks in particular mobilized to demand increased access to higher education, and these efforts succeeded. During the 1970s, the total enrollment of non-whites in higher education institutions increased, and perhaps more significantly, their enrollment in elite colleges and universities grew. But as non-white enrollments expanded, white applicants began to complain about reverse discrimination, particularly in admission to highly selective academic institutions. The U.S. Supreme Court sought to quell this controversy by addressing the constitutionality of affirmative action in the case of Regents of University of California versus Bakke. Alan Bakke had applied to the University of California at Davis Medical School. He had good grades, strong grades. He had good test scores. Yet, he was denied admission. According to at least one account, Bakke was hurt by his decision to apply late in the process. So those of you who are considering applying to law school, apply early. By the time Bakke had his interview, many of the seats in the entering class had already been taken, so he was competing for a limited number of seats. When Bakke reapplied for admission after being denied, he had already corresponded with Dr. George Lowry, the chairman of the admissions committee, about his belief that the medical school's affirmative action program was unconstitutional. Bakke's second interview with Dr. Lowry and a student member of the committee didn't go very well, and as Bakke adopted an increasingly adversarial stance toward the medical school faculty, doubts about his temperament grew, and he was rejected admission for a second time. It's not clear whether Bakke would have been admitted, but for his temperament issues. But whatever the reasons for his denial, Bakke blamed racial quotas for the denial of his admission. Under its special admissions program, the medical school at UC Davis had set aside a fixed number of spaces for non-white students, and those students were admitted with significantly lower grades and standardized test scores than were white applicants. Bakke argued that this segregated admissions process resulted in reverse discrimination against whites, including him. Interestingly, no court required that Bakke demonstrate causation in order to bring his claim. In other words, Bakke was not required to prove that but for the assignment of seats to racial minorities, he would have been admitted to the medical school. Indeed, no affirmative action plaintiff is ever required to prove that but for a school's affirmative action policy, she or he would have been admitted to the school. It is simply assumed that the plaintiff is harmed because she has numerical credentials within the range of acceptance, but schools clearly consider numerous other race-neutral factors in admissions, such as community service, extracurricular activities, and, oh yes, character, all of which can influence a decision to deny an applicant admission. After Bakke prevailed before the California courts, the U.S. Supreme Court agreed to hear his case. And in that case, no one alleged that the Davis Medical School had intentionally barred non-whites from medical school. What they did allege was that their set-aside program was a violation of the Equal Protection Clause of the 14th Amendment, and that it failed to pass the strict scrutiny test, which the court had imposed doctrinally through its jurisprudence. The strict scrutiny test, for those of you who may not know, says that in order for government to consider race in government action, it must meet two prongs of this test. One, it has to have a compelling governmental interest that it's seeking to advance by considering race. And two, the means used have to be narrowly tailored to achieve that compelling governmental interest. 4 members of the court in Bakke found that race-based affirmative action was impermissible except as a remedy for the institution's own past discriminatory practices. So since the University of Davis administration was not coming forward to say that they had discriminated in the past and were trying to remedy that discrimination, they really couldn't rely on that rationale. Another 4 justices looked to congressional and executive actions that authorize consideration of race, even in the absence of prior misconduct. In their view, affirmative action was an acceptable way of addressing racial disparities in higher education, so the Davis program was permissible. This left a tie, and it fell to Justice Lewis Powell to break the tie. In doing so, he concluded that race-based admissions practices were permissible to advance diversity in higher education. Powell found that affirmative action was not a constitutionally permissible means of rectifying general societal discrimination, nor was it constitutionally permissible means of increasing the number of underrepresented minorities in the medical profession or providing doctors to meet the needs of underserved minority communities. Instead, Powell hung his hat on the diversity rationale. He upheld the use of race-conscious admissions by invoking the medical school's academic freedom to decide who they would teach. In his view, colleges and universities could place a value on diversity to foster an atmosphere of, quote, speculation, experiment, and creation. Diversity was a compelling interest that could satisfy the rigors of strict scrutiny. It could serve as that first prong of the test, the compelling governmental interest. Bakke remained good law for 25 years, but it was on shaky ground because of the nature of that split between the justices. It was merely what we call a plurality opinion rather than a majority opinion. 4 justices had been in favor of affirmative action, but for different reasons, 4 had been against it, and Powell broke the tie. So, fast forward 25 years to 2003, and the court revisits the issue of race-conscious affirmative action in higher education again in the case of Grutter versus Bollinger. This time the court issues a majority opinion written by Justice O'Connor. They uphold the principle in Bakke that diversity in higher education is a compelling governmental interest that can justify the consideration of race in university admissions. Those of us who practice university admissions were elated that we could continue to consider the backgrounds of people who come to our institutions seeking admission and in seeking to diversify our student bodies. But this summer, we faced another case that was decided by the Supreme Court. We braced ourselves for the possibility that the Supreme Court would overrule Grutter, but thankfully that didn't happen. In Fisher versus University of Texas at Austin, the Supreme Court surprised many in a 7-justice majority and left most of Grutter intact, issuing an opinion that allowed race-conscious affirmative action to continue. However, the court's opinion in Fisher does alter Grutter as precedent and will constrain the ability and perhaps the willingness of colleges and universities to use race in admissions and other processes moving forward. Higher education administrators should view Fisher as signaling the need for change in the manner in which higher education admissions are conducted. Grutter applied equal protection's strict scrutiny framework, but took account of the First Amendment interest that Justice Powell had mentioned in Bakke, that colleges and universities have a First Amendment interest in maintaining academic freedom, which necessarily encompasses the ability to decide who to admit to the student body and who to educate. In applying this equal protection framework, the Grutter Court balanced that interest in academic freedom against the 14th Amendment interest of individual applicants to be free from racial discrimination. In doing so, Grutter permitted courts to afford deference to the judgments of higher education institutions on both prongs of that strict scrutiny test, both the compelling governmental interest prong and the narrow tailoring prong. Legal scholars generally interpreted Grutter as affording deference to the University of Michigan Law School on both the issue of whether diversity was a compelling governmental interest and the issue of whether the use of race was narrowly tailored to achieve that compelling governmental interest. At least that's how I taught Grutter until this summer. In the years following Grutter, legal scholars argued for and against the application of deference on both prongs of the strict scrutiny test. Some argued that deference afforded academic institutions in admissions decision-making process appropriate deference that they needed in order to make academic institutional decisions with respect to academic freedom. Some academic institutions you'll know have, for example, a mission where they're looking for a particular type of student, and so they might decide to admit students who coincide with that mission, perhaps a public service mission, over students with higher credentials who haven't demonstrated a record of public service. So there are good reasons why academic institutions might choose to admit applicants, not on the basis of numbers alone. Balancing the constitutional interests of the First Amendment against those of the 14th Amendment was not a novel approach to constitutional interpretation at the time that Grutter was decided. Contrary to Justice Thomas's assertion in his concurrence in Fisher that Grutter was some radical departure from the court's strict scrutiny precedent, Grutter properly took account of the fact that universities have First Amendment interests in academic freedom and appropriately incorporated those constitutional interests into the 14th Amendment strict scrutiny analysis. Even after Grutter, the court acknowledged that universities should be treated somewhat differently than other government actors in an equal protection analysis. In explaining why K-12 public school administrators' decisions to assign children to schools based in part on race were unconstitutional, the court distinguished the case involving K-12 public school education from higher education by stating that in light of the expansive freedoms of speech and thought associated with the university environment, universities occupy a special niche in our constitutional tradition. Nonetheless, the court's decision in Fisher, and that was from the parents involved case, the court's decision in Fisher repositions universities by aligning them more with any other government actor and diminishing their special position in constitutional jurisprudence and ignoring their academic freedom interests under the First Amendment. Fisher resolves the deference debate by rejecting an application of strict scrutiny that affords deference to higher education institutions on both prongs of the strict scrutiny test. Instead, Fisher constrains judicial deference to the first prong of the test, saying that some, but not total deference is appropriate there, but allows no deference on the second prong of the test, the narrow tailoring prong. As a result of Fisher's interpretation of Grutter, courts are now permitted to afford some deference to a school's educational judgment on that first prong, but no deference on the second prong. Fisher therefore constrains and narrows the holding of Grutter by rejecting Grutter's more nuanced analysis of strict scrutiny in favor of mandating that institutions of higher education demonstrate that the consideration of race is necessary to achieve the educational benefits that flow from a diverse student body, and that the methodology used by the school in its race-conscious admissions program is narrowly tailored so that the consideration of race is no greater than what is necessary to achieve the educational benefits that flow from student body diversity. Fisher mandates that courts second-guess the judgments of educational administrators by delving not only into whether the consideration of race is necessary in a given circumstance, but also whether the consideration of race was too great or too attenuated from its goal to be constitutionally permissible. Higher education administrators who want to continue to consider race, as Justice Ginsburg says, as a factor of a factor of a factor in the calculus for deciding who to admit to their academic institution, must now be prepared to articulate with specificity why they are considering race in their admissions process. They also must be able to articulate with specificity how they are defining race, why they are choosing to be conscious of particular races over others in admissions, and to what extent race is being considered in the admissions process, whether the consideration of race in admissions is actually advancing their asserted institutional goals or not. So Fisher mandates more judicial probing into exactly how considerations of race are being managed by admissions committees in colleges and universities. It asks whether the work of those committees is closely related to the institution's asserted constitutional goals, and when, if ever, will an institution know whether its continued use of race is unnecessary. It's no longer sufficient for higher education institutions to invoke a state interest in diversity. That generic assertion doesn't tell challengers exactly which of the state's diversity interests are the actual reason for using a race-conscious admissions process. So part of the problem that we see after reading Fisher is the underspecification of the diversity interest that is being sought by colleges and universities. To many, in the case in Texas, the Fisher case, the diversity rationale rings hollow, where a state legislature has enacted a law mandating admission to the state's public schools for all students graduating in the top 10% of their high school class, and because of racially segregated housing patterns that are a remnant of the Jim Crow era, we have de facto segregation, de facto racial segregation, which persists in Texas high schools. So you've got some Texas high schools that are 98% Latino, some that are 98% black, and some that are 98% white. And so if you take the top 10% of kids from all those schools, you've got a racial mix of kids who are going to be admitted to the University of Texas, including the flagship University of Texas at Austin. And so we don't need to use race, was the argument of the plaintiff's lawyer in Fisher. If an acceptable level of diversity that encompasses racial diversity can be achieved in Texas public higher education without resorting to the consideration of race in the admissions process, then under the Fisher case, the consideration of race is not necessary to achieve the compelling governmental interest of the educational benefits that flow from diversity. Once the consideration of race becomes unnecessary to achieve the goal of racial diversity, then the consideration of race is no longer permissible under our current constitutional standards. In other words, the use of race in higher education admissions must be necessary to achieve the constitutionally permissible goal of deriving educational benefits from diversity in order for that consideration of race to be constitutionally permissible. But in order to decide whether the use of race is necessary to achieve the constitutionally permissible goal of securing those educational benefits, one must know exactly what government interests are embedded in the diversity goal. In other words, what exactly does diversity mean for purposes of race-conscious affirmative action in higher education? Does the definition of diversity change from state to state? Is it related to the demographics of a particular state's population? Does diversity extend to ethnicity or merely race? And where exactly is the line between ethnicity and race? Where exactly is the line between one race and the other? How many racial categories are there? Are we using the census? Or are we using the 1855 classifications of race? Do the relevant racial categories included in the definition of diversity vary depending upon the state or jurisdiction in which the institution of higher education is located and operating? So Texas, which has a large Latino population and a large African American population, would seek to define their racial categories based on the Texas population, But states like California, which have a large Asian population, would need to include Asians in that grouping, even though we know that the majority of Asian students do not need to have race-conscious affirmative action consideration in order to yield diversity for many of them, but some of them do. So Laotians and Cambodians, for example, do need the benefit of race-conscious affirmative action to be admitted to higher education institutions in significant numbers, but Japanese and Chinese students do not. Do we disaggregate the Asian category to favor some within that category and not others? These questions crystallize the indeterminate nature of the concept of diversity that was embraced by the Supreme Court in Grutter as a compelling governmental interest. The indeterminacy of the diversity interest was a significant concern of the justices in the Supreme Court oral argument in the Fisher case. And it's directly addressed by the court in the Fisher decision, but we're left with more questions than answers. By eliminating deference to educational administrators on the narrow tailoring prong of the strict scrutiny test, the court mandates exacting judicial inquiry into whether the use of race in admissions processes is narrowly tailored to achieve the asserted benefits of diversity. And because narrow tailoring requires a close fit between the use of race and the goal sought to be achieved, an inquiry into whether the use of race is narrowly tailored to achieve the diversity goal will necessarily become an inquiry into the nature of the diversity interest itself. Now, some people ask me, why are we even talking about this diversity thing? I mean, isn't it about equal access to educational opportunity for everybody represented in our democracy? That seems to be the more logical rationale for race-conscious affirmative action in higher education. You're right. Diversity wasn't always the compelling governmental interest asserted by states that use race-conscious affirmative action policies. As we talked about earlier in the Bakke case, the plaintiffs in that case did assert a democratic rationale, but that was rejected by the court in Bakke. It's somewhat picked up by the court in Grutter, where the court talks about the importance of having people from various sectors of the population in higher education so that corporate America, the military, and democratic leaders represent the diversity of the nation. But Fisher backs away from that rationale and seems to foreclose it, stating that the only constitutionally permissible compelling governmental interest is not even diversity itself as a broad abstract concept, but the narrow concept of the educational benefits that flow from diversity. There's now public sentiment, as you know, disfavoring affirmative action, and it has grown and grown. And so it should be no surprise that the Supreme Court in Fisher is responding somewhat to that political disfavor. The question is, where do we go from here? The problem with diversity and its indeterminacy, how do we resolve it? How do we address Fisher head on so that we can maintain diversity in our academic institutions of higher education while at the same time preserving the equal protection value in our Constitution? Although indeterminacy is no stranger to constitutional jurisprudence, we see it in other areas. You probably are familiar with the pornography area as the most apt example, where the court says, you know, it's hard to articulate a definition, but I know it when I see it, right? Diversity is kind of like that, right? It's hard to articulate a definition. You could go down the critical mass rabbit hole, but you know, it is a rabbit hole there, and it's hard to articulate what exactly we mean by critical mass. We've tried to avoid placing a number on critical mass to say we need 10% of the student body to be African American or 10% of the student body to be Latino, because if we do that, we run the risk of being labeled like the Bakke program as a set-aside or a quota program, or as Fisher warned, engaging in racial balancing, which the court held in Parents Involved was unconstitutional. But the effort to avoid having an affirmative action policy deemed a quota has pushed affirmative action advocates towards argumentation with higher levels of abstraction toward this diversity abstract concept that the court in Fisher seems to reject. The use of the general concept of educational diversity as a compelling governmental interest has facilitated the ability of affirmative action jurisprudence to adapt to changes in facts and circumstances in higher education, as well as the evolving sentiments of the public surrounding affirmative action in higher ed. When empirical evidence or social change outpaces existing understandings of law, the use of general abstract principles actually preserves room for judges to mold legal jurisprudence over time to be consistent with public understandings and public concerns. By avoiding analytical precision in articulating the state's interest in diversity, educational diversity in the abstract served to provide a generic rationale for the maintenance of race-conscious education admissions while giving higher education institutions time to conduct empirical research to measure the need for race-conscious intervention, as well as to gather evidence regarding the manner and degree of intervention that was necessary and appropriate. But rather than add to the clarity of the diversity rationale, the case for educational diversity was weakened when courts found themselves with competing evidence about the benefits and harms of race-conscious affirmative action. Until Richard Saunders' controversial work on affirmative action, it was simply assumed that, aside from the stigma argument, race-conscious affirmative action policies generally benefited racial minorities while burdening some individual whites in the majority. But Saunders' work has challenged that assumption by asserting that race-conscious affirmative action actually harms African American students more than it helps them by mismatching them with academic institutions that do not teach toward their level of preparation, but rather above their level of preparation, thereby making it more difficult for these students to succeed academically. This mismatch theory is further intensified, Saunders asserts, when the academic institution imposes a curve in grading, such as we do in law school, thereby making students compete against one another for a grade. So in law school, not everyone in the class can earn an A or a B. There is a mandatory curve. Saunders' work suggests that the educational benefits that are derived from diversity achieved through race-conscious affirmative action may be outweighed by the harms of race-conscious affirmative action. Harm to not only those whose race is not affirmatively sought by admissions policies, but harm to the intended beneficiaries of race-conscious affirmative action. Saunders' work suggests that race-conscious affirmative action may actually be hindering or hurting the educational achievement of racial minorities that it's intended to help. Now, I disagree with Saunders' thesis for numerous reasons, which I'm happy to talk to you afterwards about, but assuming courts accept his thesis as correct, and the use of race-conscious affirmative action policies in higher education admissions causes an academic mismatch that results in more minority students either failing out or underperforming academically, then the asserted educational benefits for all students that are derived from a diverse student body are arguably no longer sufficient to serve as a compelling governmental interest that satisfies the first prong of the strict scrutiny test. The Fisher decision's prohibition on affording deference on the narrow tailoring prong of the strict scrutiny test will push lawyers to unpack the content of diversity and articulate its meaning with more specificity. The demand for specificity in the articulation of the diversity interest will arise because the need to consider race, the degree to which it is considered, and the manner in which it is considered are all closely tied to the diversity goal that is articulated by the higher education institution. In other words, now that the court is requiring this exacting judicial scrutiny into the narrow tailoring prong, judicial assessment of whether the consideration of race is narrowly tailored is even more closely connected to the asserted compelling governmental interest of achieving the educational benefits of diversity. If a school's consideration of race in admissions weighs so heavily that the academic dismissal rate for black students at the school is significantly higher than the dismissal rate of whites at the school, or the dismissal rate of blacks at the school that do not use race-conscious affirmative action is better than the dismissal rate at schools that do use it, it could indicate that the use of race is not achieving the desired educational benefits for this group of students. So while debunking racial stereotypes and preventing racial isolation are important educational goals too, those goals are not as compelling when pitted against the paramount goals of minimizing academic attrition and maximizing graduation rates. The court in Fisher asserts that the pursuit of diversity for its own sake is the equivalent of unconstitutional racial balancing. So no longer may academic institutions pursue diversity for the sake of diversity. It may only be pursued for the sake of deriving those educational benefits. So we're going to have to articulate exactly what those benefits are. It's going to take some work. It's going to take some experimentation. And Fisher's narrow articulation of the diversity interest suggests that only the state's interest in diversity, which yield a significant educational benefit to the student body, are going to suffice as a compelling governmental interest under the strict scrutiny test. So as administrators, we're going to have to come armed with proof that our use of diversity, our use of race, is actually benefiting the education that we deliver to our students. It's actually improving the education, enhancing the education we deliver to our students. Under this narrow conception of constitutionally permissible diversity, the state's interest in making public-funded higher education equally accessible to all races, or achieving racial equality in educational outcomes, those arguably would not be sufficient state interests, sufficient to constitute a compelling governmental interest. The court in Fisher has basically ignored that public institutions of higher education have a duty to the public as well as a duty to the students they enroll. The court has overlooked one of the core missions of public colleges and universities, which is to provide education to the diverse citizenry of the state. By constraining the diversity interest to only the interest in using diversity to achieve educational benefits, the court has created an unnecessary disjuncture between public and educational interests in diversity in higher education. In particular, the concern is that the court has invaded the academic freedom of colleges and universities by redefining and restricting the educational mission of public higher education. By narrowing the mission of public higher education to the interests of what happens in the classrooms and with educational outcomes such as graduation and attrition rates, the court minimizes the other roles of public colleges and universities. In reality, many public educational institutions have a mission to conduct research, participate in community and economic development in their state, and educate individuals from all segments of the state's population. In fact, that is the mission of the university for which I work, Penn State. By constraining this diversity interest of universities to only the educational benefits derived from diversity, the court improperly constrains the academic freedom of universities to define their missions much broader. Educators in higher education have a responsibility for the quality of education, which includes instruction, research, and outreach. Quality education implies a responsibility for inclusive education, but this obligation was unfortunately overlooked by the court in Fisher. With increasingly public hostility toward affirmative action, it should come as no surprise that the court would sharpen and refine these parameters. But I urge us all who are administrators in higher education to think about the ways that we will restructure, that we will reconsider administering higher education admissions so that our doors remain open to people from all segments of our citizenry in the various states in which we operate. Because we are still 148 years later after the Freedmen's Bureau, we are still suffering the effects of slavery. We are still experiencing racial inequality in education. And so we need each and every one of you in this room to work toward achieving racial equality in higher education. Thank you so much for your time.
So now we'll take questions. you discussed how it's been narrowed down to state interests and diversity, and I wanted to know what implication that has on state or public universities versus private institutions. Do private institutions have more leeway in making decisions as far as their admissions is concerned, or does that encompass both types of institutions?
That's a good question. So there are two theories on that. So far, the schools that have been sued have been public institutions because they're the easy targets. But the theory is that even private institutions could be sued in theory under a Title VI argument because they receive federal funding. And so it's possible to bring a claim against a private institution as well, although private institutions are a little more insulated under what we call the state action doctrine. It would be a bit more of a challenge. So when a lawyer is thinking about bringing a case, they want to find the perfect defendant, right, who they're more likely to win against, and so they're more likely to bring a case against a public university. Great question, though.
And here you go. President of the United States.
There's a question over the top.
So I heard that some people have suggested the focus on socioeconomic action as a way of giving opportunities for racial minorities and not deal with this issue. Can you share your thoughts about that?
I can barely hear you. Could you just repeat it for me?
Use the microphone.
Oh.
There.
Thank you. Some people have suggested to focus on socioeconomic affirmative action as a way to also give opportunities to racial minorities and deal with the things that you were talking in your presentation before. Can you share your thoughts and opinions about that, please?
Oh yes, that's a great question. So, in fact, Richard Sonder in his book says that we shouldn't abandon affirmative action altogether. We should just shift it from being race-based affirmative action to class-based, right? Two things. One, most sociologists consider socioeconomic status to comprise race. So race is a component of SES that arguably cannot be extracted because it's so integrally connected to socioeconomic status in the US. So many sociologists say that you're really talking about, like it's saying after you've scrambled the egg, just take the yolk out. You really can't do that. So they're saying you really can't disaggregate race from socioeconomic status and conduct this truly race-neutral analysis because race is a component of SES. So that's one piece. The other piece is that if we considered SES or class, right, how would we do it? Would we do it based on the family's income or based on the family's wealth or based on the family's income and wealth? How would we ascertain that? How would we verify? For example, right now in the financial aid process, you fill out the FAFSA, you know that you have to give your parents' income, some information with respect to wealth. So we could start there. But the question is, would we yield the same amount of diversity that we have now? Most people think that we would not because our society is simply a majority white society, and we have the majority of our people in our society who are poor and lower socioeconomic status are white. So while we have people of color, blacks and Latinos, who are disproportionately suffering in poverty and the lower rungs of the socioeconomic ladder, their raw numbers are such when compared to whites that if you just did it on SES, you're probably not going to yield the racial diversity that you want. You'd get the SES diversity that you want, and it would improve SES diversity because even now in institutions of higher academic learning, we see that we don't have the socioeconomic diversity at the higher rungs of the elite flagship universities across the country that we would like to have. And so when we look at SES, we see that there's this stratification where students with lower SES or from families with lower SES are at lower ranked institutions generally. A lot of kids with low SES but high numerical numbers even don't apply to the elite colleges and universities because they figure I just can't afford that, right? And so SES diversity also wouldn't work because people feel priced out. So they might be admitted, but they won't necessarily matriculate there because the price tag is such a sticker shock. Thank you, that's a great question. In the University of Texas case, the Fisher case, even though 10% of all the kids at the top 10% of all the high schools are admitted to the University of Texas at Austin, only 1 out of every 17 black students who are automatically eligible for admission even apply to the University of Texas at Austin because they know they can't afford it. So.
Hi, so I guess I'll just talk from here because I'm right here. But if nobody can hear me, just let me know. So as...
They might not be able to hear you over there.
So as our understanding of race and how we view race changes, obviously, significantly over time. I mean, not 70 years ago, Japanese were being thrown in essentially camps, and it was a slur to be German, et cetera, et cetera. As our understanding of race changes over time, especially given the growth in the Hispanic demographic and projection of white being majority-minority, how are you seeing the diversity goals changing over time?
Yeah, that's a great question. I think for public institutions of higher education, I certainly feel a duty to the citizens of Pennsylvania to educate the children of Pennsylvania, first and foremost, right? So Penn State, we've got 24 campuses across the state in order to implement that mission because we recognize that not everybody has the privilege of being able to afford to pack up and move to go, quote, away to college, right? Some people need to live at home, work part-time, and go to college. And so having that campuses spread across the state makes education accessible to people across the state. And so I very, very much believe that that is an important component of public education. So in that, then, I think you have to look at the demographics of the state in which you reside. So I do think it would be appropriate to say that if your state is 30% Latino and you only have 3% Latino students at your institution, we're doing something wrong, that we are not making our education equally accessible to this segment of our population, this segment of our citizenry. But we have to be careful not to engage in racial balancing, right? Because that's clearly unconstitutional under both parents involved in Fisher. So we can't say we've got to admit 30% of our student body has to be Latino because 30% of our state's population has to be Latino. But we can certainly strive to do better when we see our numbers are at 3% for admission and our population is at 30%. Yes, you had your hand up for a while.
I just wanted to return to the socioeconomic issue. You stated that minorities, racial and ethnic minorities, are disproportionately affected by socioeconomic disadvantages. So my question would be, is it the race or the socioeconomic disadvantage that's causing the disparity in higher education? Because even if you admit 1,500 racial minorities, if half of them can't afford to go, how can they balance that quota? So I just wonder, is it the race or is it the socioeconomic inequality that's affecting the disparity?
Yeah, and I think I would say that you can't detach the two, right? That race is a component of socioeconomic status, and so it's affecting the whole process. But you're absolutely right that socioeconomic status is the engine driving the train across the board. So when students ask me about the LSAT, they're like, "Oh, that LSAT test. How many people in here are taking the LSAT? Anybody? Yet? Okay. Was it easy?
No.
It's a hard test. It is harder than the bar exam, if you ask me, okay? So people take the test and they're like, that test is biased. We know that Latinos and blacks perform less well on the test, so it's racially biased. I'm on the diversity committee for LSAC. LSAC is the organization that formulates and administers the LSAT test. The test is not racially biased. We could put all kinds of culturally biased questions on the test that are culturally biased in favor of African Americans and Latinos, and whites would still outperform blacks and Latinos on the test. Why? Is it because whites are smarter? Why? No?
They can afford test prep.
Who said it? Resources, right? Whites are the group, the racial group, that has the majority of the resources necessary to prepare for whatever we put on the test, right? So they can muster the resources to prepare better, and they will outperform no matter what we put on the test. So it is about socioeconomic status at the end of the day. That is the engine driving the train. But if we only look at socioeconomic status and ignore race, we will end up with socioeconomic diversity in our higher education institutions and not racial diversity, because like I said, we've got so many people in the white category in this country who are working class and poor that, you know, we wouldn't necessarily yield the racial diversity that we're trying to seek.
Tyson was kind enough to give me this from my grandchild, so I'll ask a question. And I'm not sure whether it's a question or more of a statement. Based on just your last response about what happens, whites have more resources, and so therefore they're going to test better no matter what. I have some concern that these strategies decouple K-12 from K-16 education. And until that is fixed, I don't care what you do in terms of affirmative action and reverse discrimination, nothing's going to work. Do you understand the point I'm making?
I definitely do. I agree with you totally. In my book, The End of the Pipeline, I make this point. The reason that affirmative action is, you know, necessary is because we are not doing the job at the K through 12 level. If we were doing that job appropriately in this country, it would dislodge what Professor Daria Rothmeyer calls locked-in racial inequality, right? So if you think about any economics majors in here, okay, so if you think about a monopoly, right, a cartel, the first mover in the marketplace gets the advantage, and that, you know, kind of like Microsoft did, and that advantage just snowballs, right? And so when other movers try to enter the marketplace to compete, it's really, really hard, right? So how do you get rid of that monopoly? What do you have to do?
Break it up.
You have to break it up. How do you break it up? Law has to intervene, right, and say monopolies are not allowed. We're going to break this up. We're going to form smaller companies. You probably saw American Airlines and US Air tried to propose a merger recently, and the Justice Department said, that's an anti-competitive move. It's going to reduce competition in the marketplace and drive prices for consumers up. We're not going to allow that, right? So it's the same thing when we're talking about a racial monopoly. Whites have a racial monopoly on resources in the US, and until we have some affirmative action that breaks up that monopoly, there isn't going to be pure equality across the board, and we haven't seen it. Affirmative action is not a sufficient force to break up that racial monopoly. It's just a little bitty, you know, a little bitty pebble flung at the big mountain. It's not, you know, it's crumbs off the table. When we look at the numbers of students who are admitted through race-conscious affirmative action programs, it's de minimis compared to the number of students that we educate across the country. And so we're talking about crumbs off the table with affirmative action. It is, you know, not hardly enough to break up that racial monopoly.
Would you be in favor of all public schools receiving equal funding instead of the funding being based on the area of economic?
That is an excellent idea. Thank you. That is an excellent idea. I would be in favor of that, but there's no political will for that, right? You know, parents in this country say, I'm going to sacrifice, I'm going to buy a house in the neighborhood where the school is good, and if I have to drive that old car for 15 more years, I will, and if I have to pack my lunch and take it to work every day and not buy lunch at work, I will, right? And we just hunker down and we do the best we can for our kids, and then we hope that they will do the best and that each generation will improve a little bit. But that philosophy ignores the reality that we've got people in our society who simply don't have any extra resources to allocate towards that process, right? And so they're merely trying to get some housing somewhere, right? So that they have some roof over their head. They don't have an option of buying into the, the area with the better school system. But there's no political will to reallocate the taxing mechanism for funding schools, because the thinking in America, remember, we are a capitalist society, and so there is a bit of this sense that you earn your position in America, right? And that if those kids don't have it, it's because their parents aren't working as hard as I am, right? And so that mentality would have to change, and we would have to become more communal in terms of our view about one another and one another's children. And we'd have to think about America's children as all of our children, instead of thinking in terms of, I want my kid to get the best education that they can get so they can get ahead of all those kids. So right now there's this perverse, incentive for people to actually continue with the existing model, because we don't have enough seats in higher education to educate everybody as it is. So we depend on those kids at the bottom staying out so that we can all have a seat here. Sad, but true.
Where would you feel like that this change, like towards, I guess, an effort of taking affirmative action into our conscious, where would it start? Would it start with the law, or would it start with like somewhere else? Like on a large scale, like the federal government taking action, or municipalities like starting to take action?
Well, I think this gentleman's question is a good one in that, I think change would have to come from the bottom up. So not from the federal government down, not from the top down. That, he could start a movement in his community to change the way community thinks about its children, right? That, wait a minute, this is Baltimore, we are a city. It is not fair that children on this, I don't know Baltimore, so I'm just pointing to that side of town, I don't know. It's not fair that children on this side of town don't get as good of an education as the children on this side of town. They're all Baltimore's children, right? So if a grassroots movement sprung up and the political will emerged to change the taxing system so that all schools got the resources that they needed, then we could see some change, right? But it would be on a state-by-state basis. It would come from the bottom up. Preston Green, who used to be at Penn State, is now at University of Connecticut, has written extensively about the difference that funding makes in terms of educational outcomes, assuming appropriate stewardship of funds. So we could make some significant changes in the K-12 system through equitable funding.
One last question. Go ahead.
I was just going to ask really quick, with America becoming more and more diverse, how do you see affirmative action with people who may associate with different races? They may have a Latina mom and an African American dad. So how does that sort of play into affirmative action when you're looking at mixed race couples and children?
Yeah, I mean, that's exactly one of the questions that I think we're confronting. So I'll switch the question a little bit, because we're confronting an issue with respect to the Black population at many institutions of higher education. It's changing in the nature of the population, right? So we're seeing fewer African Americans and more students from Africa and the Caribbean who are Black, right? So they still are Black, right? But they're not the children of the descendants of the slaves that were mentioned at the beginning of my talk, right? And so there's some concern that legacy blacks, they're called, right, are being left out of our educational system, and that those were the actual people that affirmative action was designed to benefit in the first place, right? And so I think we do have to think about who it is that is in our society and make sure that everyone has a seat at the table, right? People now can self-identify. So if someone wants to say I'm half Latino and half black, they can. And that enhances the diversity in the institution, right? But so to have mixed race people is a good thing. To have biracial people is a good thing. To have monoracial people is a good thing, right? We want people from all categories, right? So that students in college can say, oh, you know, I never really thought about that. I thought you had to be one race, you know, when they meet that person and that person says, well, I'm Mexican and I'm black, or I'm Latino and I'm black, or I'm Afro-Latina, right? That might be the first time that student hears the phrase Afro-Latina. I didn't know such a thing existed, the student might say, right? And so it's encountering people with those different identities that is going to enhance all of our experiences on campus.
Well, thank you. Let's give our speaker a hand.